Hi, my name is Shaun Carr, and I'm from Logistics Insurance Advisory. I have today with me Tom Schulte from Scopelitis, and we're going to talk a little bit about the National Defense Council strategy. Tom, I'm going to kick it over to you. How you doing this morning?
Doing well, sir. Thanks for having me. Again, my name is Tom Schulte. I'm with Scopelitis. We're a national transportation defense firm, do everything for transportation companies. However, my practice focuses on defending transportation companies in highway accident claims. What we want to talk about, and Shaun wanted to talk about today, is the National Defense Council strategy that we've developed over the last 10 to 12 years. And what that involves is where a company hires us to coordinate not only the emergency response on highway accidents, but also the claims process. And on the emergency response, that's from the moment that the accident happens, where we're called, and as the defense counsel and transportation defense counsel, we organize the emergency response. And we work as a team approach, not only with people like Shaun, but the safety director, anybody else from the company, the insurance company, and we'll do that by retaining the reconstruction experts, the IA. And then that usually is about a 48-hour to 72-hour process. And then if it ends up in litigation as National Defense Council, then we defend those cases. And part of that is our spread across the country is if we need transportation specific defense counsel at local counsel, let's say in Las Vegas, we have the connections to know who to go to, because you have to have somebody boots on the ground who knows what they're doing, not only from a local, they know the local judges, the mediators, but also obviously from the state rules. So that's kind of the development of the program.
So Tom, I'm going to ask you a question. Why is the team process important? And maybe just describe that team for us.
The team would consist of obviously us as defense counsel, we coordinate it. But if you have an insurance advisor, the safety expert from the motor carrier and the insurance carriers, we work together to determine what resources to devote to that specific accident, and then develop how the accident develops in our investigation. Then we make strategic decisions on how to respond to that claim. Is that a claim that we should try to settle empathically early, or do we have great liability defenses and we need to shore those up so we can defend that claim if the lawsuit's filed?
So Tom, I'm just going to interject here. In most cases, the insurance carrier would have to approve the process, but in effect, initially, you'd be acting in a general counsel capacity, and my role is to act in a risk management capacity. So those two things kind of converge, where we decide is this good money to spend or not. And I have that background to see the large case development and kind of the retentions for the motor carrier, and then we can help make decisions. So what I like about the team approach is that those decisions are made collectively, and it's not like it goes off to an insurance carrier and they're going to decide. No, we're all going to be on the loop on this, because ultimately the motor carrier has responsibility.
Absolutely correct.
So, Tom, maybe talk a little bit about when we get initially involved in these cases. What are those things that you do that really what are those services that you provide?
Sure. From the moment, and this is kind of the emergency response protocol, we will immediately engage a insurance adjuster who's transportation specific. And I can't emphasize that enough. Not only with the reconstruction expert that you're going to retain, you need people on your team that are transportation specific and not just general mill experts or independent adjusters. So we'll dispatch them to the scene to collect and preserve evidence. And then as part of that, also, I will interview the driver. And that will be protected by the attorney-client privilege, which is important because the driver is going to reveal and talk more openly with an attorney that's protected by the attorney-client privilege than just with a regular adjuster. And it's important to get the driver's statement up front and then compare it to the other facts. Because sometimes you can help develop the driver and what his testimony perhaps is going to be down the road. That's particularly true with when you're involving a dash cams, whether it's inward or outward facing, because you want to make sure that if the driver is credible and compare that to the dash cam. So that's some of the services that we initially provide.
Thanks, Tom. What I want to talk a little bit is about the timing and compare standard industry practices. So the standard industry practice would be for an desk adjuster to manage that case and maybe use outside field investigators. Whereas we're bringing attorneys in up front, and we feel that's a much better strategy. And I think the attorney-client privilege is often overlooked. Maybe just talk just a little bit about why that's important.
It's important because the entire investigation is going to be privileged. Meaning, if they file a lawsuit, if it's bad material that comes out in the investigation, we necessarily don't have to produce that during discovery. But that's particularly important with respect to your reconstruction expert, because the reconstruction expert, if it's a case where that turns on liability and it's clear based on his opinions that he believes we're at fault, we never have to reveal those opinions if the case is filed later on. And now that you can strategically use that to try to settle this claim early because liability is not favorable. But the key is all of it's protected by work product attorney-client privilege. And if you ends up in a lawsuit, you don't have to turn it over unless it's unless you want to.
Well, what I like about it, Tom, is that we're taking a very proactive approach. We're not just sending off an insurance carrier. We're taking a very proactive approach, and we're bringing the resources that we need specific to that case. So if it's a smaller case, we certainly don't need as much, but if it is, it's there. And we're usually doing this within 24, 48, 72 hours, correct, Tom?
Absolutely. And, whereas I've been in situations where defense counsel's not retained until after the lawsuit's filed. That could be 18 months down the road. And it's where the desk adjuster is doing the investigation, that those are not going to be privileged. So anything that they do is going to be discoverable. Not only that, just to be honest, most of the time they're not transportation specific desk adjusters. Even if they were, they don't have the knowledge to direct a fatality or a catastrophic injury investigation.
Thanks, Tom. Let's pivot this to take it from the client's perspective. And what we've seen with the actual cases we worked on is that having a proactive strategy, having these things out front, communicating them throughout the organization, the motor carriers organization, ultimately should produce better claims results, particularly on development. So how many times has it been that right before the end of statute of limitations, some little fender bender hits the desk and we have stale information? So in the cases that we've been involved in, that we've investigated and we've put those resources in, we will have very good information and we'll be able to defend that case from the day that the suit comes in. And the way I feel, and I feel pretty strongly about it, that those cases will not develop as much as that if you took the alternative approach, which is just to send the cases to the insurance carrier. Any comments on that, Tom?
No, I agree with Shaun, and I'll give you an example. In that stale claim, where it's a minor fender bender, nothing's done on the investigation side, 2 years later, right before the statute runs, you end up with a lawsuit. If you actually do take time to investigate it, you may do a surveillance. I just had one of these the other day where you're going to do surveillance within the first 60 days. And we caught this gentleman playing softball. And now that he's filed a lawsuit, we use that to convince the plaintiff's attorney, there is no claim here. Your gentleman's lying. And we settled for nuisance value. So a proactive approach is very important from the client's and the motor carrier standpoint.
Well, that's great, Tom. So look, for the people viewing the video, this is not intended to be an exhaustive review of your claims process. This is just an idea, and I think the overwhelming message is here: have the right people involved in your claims, be proactive, and Tom, maybe just how would, if someone's looking at this video, how would they get a hold of you?
They can call me at my direct lines, 317-492-9274. My email address, tschulte, SCHULTE at scopelitis.com. Or I'm always on the internet also.
Beautiful. And just so you know, my role is risk management advisory, and I kind of fit between everyone, and I help people sort through this process. I've been doing this a long time, and I can help facilitate great results for difficult situations. So, anything else to add, Tom, before we adjourn?
No, I guess what I just emphasize again is it's so important to get defense counsel engaged from the very moment the accident happens. You're going to put yourself in the best position possible, not only to resolve these claims before the lawsuit happens, but to defend them once a lawsuit does occur.
Thanks, Tom.